Okay, good morning. We're with Judge Claudia Laird, and she is running for her office right now, county court position 2.
Yes, sir.
Okay, and with me, I'm John Wertz. This is with me is Maureen Ball, Bob Bagley, Dennis Tibbs, Pat Tibbs, and Larry Rogers. And as we discussed, we'll go ahead and start with your up to 5 minute opening, and then we'll begin the Q&A.
All righty. Well, good morning. My name is Claudia Laird. I'm the judge of County Court at Law number 2 here in Montgomery County. I am in my 2nd term in that office, and I just want to say, starting out, number one, thanking the people of Montgomery County. I love my job. I love what I do. It's a wonderful, wonderful place. It's very challenging, but it's a very good place to work. And I'm sorry, I'm not talking loud enough. And normally people are having to tell me to lower my voice. I'm sorry. I do enjoy my job, and I love what I do. County Court at Law number 2, I think the most important thing you can know about that court is it handles a bifurcated caseload. We are half probate, and people who are watching this that haven't heard that term before may confuse it with probation. I am not saying probation, I am saying probate. Probate is the law dealing with wills and probating people's estates after they pass away. It also deals with guardianship, which is the way that we take care of people who are intellectually disabled that can no longer make decisions for themselves. It's a judicial proceeding or a jury proceeding by which a guardian can be established to help take care of and make decisions for that individual. Our court is the only court in Montgomery County that handles those types of cases. In addition to that, we handle civil cases, and I always tell people you're in a civil case if you haven't been put in handcuffs and given a ticket. So those would be contract cases, car wreck cases, things of that nature. We do not handle family law cases or criminal cases, although I do volunteer for the other judges occasionally to handle criminal cases if there's any backlog or they need any help. And I guess the most important thing that I can tell you about my performance in this court, and I'm very proud of it, is since my time in this court, County Court at Law number 2 has been recognized by the Texas Office of Court Administration. We are the model court for the entire state of Texas for guardianship administration. We are doing so well in this aspect of what we do that I have been asked to testify as a judicial expert on guardianship administration to the Senate State Affairs Committee. They called me and asked me to come testify in their hearings. I am also frequently asked by the Texas College of Probate Judges, the Center for the Judiciary, and the State Bar to lecture on guardianship. And so right now there's a big push in guardianship to make sure that disabled people in Texas are appropriately handled by courts, which is a challenge because when you ask a court to handle a guardianship, what you're asking them to do is be a social services agency, be an investigator, be an accountant, and be a judge. And our courts aren't adequately staffed to do that. I have been blessed in that my commissioner's court have seen the need for the staffing and have given me the staff to be able to adequately take care of our guardianship cases. And so those would be the most important things that I can tell you about County Court at Law number 2 and what I've been doing in my time there.
Okay, great. Thank you very much. You had indicated your strengths in estate probates and guardianship cases, and also being a model court. That's fantastic. High accolades, and I know we're all appreciative of that. Kind of an HR question. So those are strengths. What would you say some of your weaknesses are in that area?
In guardianship, a weakness. I can't think of one. I don't mean to sound, gosh, that sounds so arrogant. I guess the thing that I always worry about with guardianship, we have about 463 guardianships right now. So a weakness and a challenge, I would say, for our court is to, we have a court visitor program, which is something that I also started in our court. And it's to, when a guardianship is started, you might have an individual who has Down syndrome. They get a guardianship at 18 when they become an adult. Well, that guardianship will often stay in place because it's a lifelong disability a lot of times. It will stay in place until they pass away. It could be 40 years. And we never see that individual back in court. So it's kind of like you put your blessing on them and give someone authority over them and send them out to the world, and then you don't really know anything other than what the guardian is telling you. And 99% of our guardians are good, wonderful, loving family members and good people. But you're always worried about that 1%. And so the challenge for our court is to find, I always say it's like finding a needle in a haystack. And you know it's going on somewhere, and so it's just a constant vigilance of trying to be out in the community and get eyes on our visitors, so the court visit, or on the awards. So our court visitor program is a group of individuals, students, whoever we can get to educate, train, and go out to lay eyes on these individuals at least once a year in situations where we've had no problems and it's the parents. We'll do it once every 2 years, and that's because a lot of times the parents are very burdened with all the visits they have to do from social services agencies because their children are disabled. So we're trying to balance not putting more strains on them while they're trying to help their kids, while also managing them and keeping an eye on them.
Okay, great, thanks. Mark?
Related to guardianships and your ability to go to the legislature, have you been able to combine that and make an impact somehow?
I have. I go to the legislature. I've been going to the legislature the past 2 legislative sessions. We've been successful in getting some good legislation passed. The first time I went to the legislature, Will Metcalf was kind enough to take some legislation for me. And so the problem that we were having around the state is if one of our wards got arrested and they do have intellectual disabilities, sometimes this leads to them getting into criminal trouble. And then they don't understand and they get in the jail. Well, the problem that we were having is a jail has to have the inmate put your name on a visitor list. Well, if you have someone with an intellectual disability in the jail, it's hard for them to fill out paperwork. So their guardians were not being put down as visitors, and then the jail wouldn't let the guardian in to see the ward while a criminal proceeding was going forward. And so that just can't happen. So we got some legislation saying that if a jail is presented with a valid letter of guardianship, they have to give the same type of visitation that another visitor, that a visitor who was on the list would get. The guardian now can also go and fill out financial questionnaires and make a request for appointed counsel, which used to also fall on the criminal defendant, which again, an intellectually disabled person who's already been adjudicated by the court as such doesn't have that capability. So those were 2 important things. And then the last legislative session, Senator Zaffarini carried a bill for us, which made it so that there is going to be, her bill was to make a database in Austin of guardianships, but my little part of that bill was that database will transfer into the police officer's database so that when they run an individual in their vehicle, it will automatically pop up, hey, this person is a ward, they're under guardianship, and this is their guardian. So that's really important for a police officer to know he's dealing with someone who's intellectually disabled.
Bob?
Is there a high percentage of cases in Montgomery County for guardianship?
No, I wouldn't say it's a high percentage of cases. We have about 500,000 people in Montgomery County, and when I first took the bench, we were hovering just under 500 guardianships in the 490s, and that was pretty standard. And then they passed some legislation to give other options other than guardianship, which is always important. People don't understand, you just don't want to run out and get a guardianship over someone, because when you do, these are constitutional issues. I take all the rights away. That's a big deal. We don't even do that to criminals who are incarcerated, take all their rights away. But somebody who is a ward under the court has if they're under a full guardianship, they don't have rights to make decisions for themselves. So there's been some moves in legislation to create other types of things in lieu of guardianships to help these individuals. And so we were able to go through and kind of reduce the total number of guardianships, which is kind of a goal, and using that legislation. So it's now hovering around in the 460s. So no, I don't think that's a huge number of cases, but when you think about, we have basically 7 people in our court, 2 are dedicated to civil, 1 is dedicated to estates, which leaves 4 people to handle 460 some odd ongoing guardianships that don't go away, really. It's a lot of work. So no, not a high percentage, but it's a really important job, and you know, you need to make sure that you're giving it the attention it needs, because the last thing you want is something bad to happen to one of these people on your watch.
Well, like you said, it's ongoing. It never ends.
Those cases, it's not like a criminal case that you get a conviction and then some appeals and eventually it ends. It lasts typically their whole life, or some of them they get recapacitated, which is always a happy day, and we restore their rights and send them on.
Okay, you mentioned that sometimes you take civil cases, which the same sorts of cases that go to the 284th?
Exactly, the same sort. And it's not sometimes.
Yeah.
It's actually half my caseload. We typically take, on average, about 1,000 civil cases a year. So we have about 1,000 probate, 500 guardianships, and then about 1,000 civil every year.
Okay, so you don't just take some of the probate cases, and you don't take all of the probate cases and then use your leftover time with civil. You actually have a backlog of both types of cases?
I don't have a backlog.
All right.
I have a responsibility to handle a certain percentage of the civil cases. That would be all of the civil cases that only have jurisdiction in the county courts at law, because I'm the only county court at law judge that handles civil cases. I have joint jurisdiction with the district courts on certain civil cases. So anything under $200,000, I have joint jurisdiction with the district courts. So I take a big percentage of those cases, the 284th takes a big percentage of those cases, and then the 410th takes another percentage of those civil cases. But those are the only courts right now in Montgomery County handling civil
And the
cases.
time that's allocated to the probate work is sufficient to handle all the cases?
Yes.
All right.
Arguments?
All right, yeah, for 46 seconds.
Did you have questions or?
Okay.
Okay, well, good, he had an extra minute left over,
Oh, you don't.
but,
Yeah.
first question, you've been, under your leadership, you have the model court, the state, and guardianship. Could you tell us what makes a model, or what makes that so special?
Well, I mean, there's 2 ways to look at your question. What makes it special is that, you know, it means we're doing good on something that I think is very, very important.
What are you doing good that makes it?
And so the simple answer to your question is we pay attention and we care. And it's very funny when you're involved in a guardianship, at least when our court is involved in your guardianship, we almost feel like we become this member of the family, and what the family is going through, we're going through. We had a lady call us who we don't even have a guardianship over her son anymore this week, but because he was restored, which is wonderful, but she called us and she was like, will you please help me make him take a bath? And I mean, that is really, these are the calls we get on a day-to-day basis. It could be something as simple as that, which is kind of funny. And it could be something as complex as we get a report from APS that there's been a neglect finding and a stepfather has raped one of our wards and is still living in the home, which I have also had happen. So every week something happens in one of our guardianship cases. So we try and make sure that we keep contact and we reach out to the families. We try and help them when they reach out to us. We just try and do everything possible to be there and help these people in any situation that they might get in. But we just try and pay attention, but you have to have the heart for it, you have to care. We'll see our wards walking down 105, and we'll go, hey, that's Nicole, what's she doing? Why is she here? Who is she with? And we see that all around the county, and so my staff's kind of always on the lookout and questioning, are they okay, is everything okay? So that's kind of what we
Which leads
do
into
at Special.
the second part of my question, and I'm gonna take this a minute that's left over, which you just kind of touched on answering my question. How do you monitor the guardianship? Because you said it's an ongoing thing, so give us a little more specific, how do you monitor it?
Okay, so let me explain. Number one, there are some legislative requirements. The individuals who are guardians are required to report every year. Now, that's not a lot, 365 days, and once a year, they give us a report. The report has all the information about the ward, who their doctors are, if there have been any changes, any information to kind of glean a general snapshot of what's going on with this ward. They're also required to give us financial accountings if there's an estate, which sometimes wards, especially if they're adult wards who have maybe gotten dementia on the end of their life, they might have accumulated a large estate. And I think the last report said that our court was in charge of $25 million worth of these individuals' assets. So we're responsible for auditing those. I specialized all our court staff. So we have an individual now where instead of just taking every kind of case, civil cases, guardianship cases, probate cases, her sole function is to audit those financials. And I have trained her using my white collar crime experience from the district attorney's office to really drill down, and she's looking for crimes. She's looking for theft. We have one individual who is our court investigator. Whenever we have any flags, someone calls us and says something's wrong, there's an APS report, there's anything in those yearly reportings that trip a red flag, our court visitor says something like this doesn't look right, we immediately send her out and have her look into it. We also have another individual who's our guardianship coordinator. Her job is basically to do intake on all the cases. She's the person that's making sure that as the cases come in, there are legal requirements that have to be done. There has to be an ad litem appointed to represent the proposed ward. There has to be an investigation done to make sure that no one's just coming in saying, hey, we need a guardianship over this person, but the person's fine, or there's some power of attorney in place that they don't need a guardianship because they've already decided while they were capacitated, no, this is who I want to take care of me, and this is who I want to take care of my things. And she makes sure that service is done on all the individuals, so she's making sure all those check boxes are checked. So it's by those essential three functions, and then me kind of being the matriarch and round tabling and being the final decision maker on this is how we're going to go forward, this is going to be what happens. But if you don't have those four things in place, you're not going to be able to manage a large number of guardianship cases. And that's what I teach other judges when I go out. I tell them you have to go, I understand if you're from a small county, you have to go to your commissioners, because you can't be out on the bench trying cases and worrying about what all these people are doing running around in your community. You have to have people to do that for you. If you don't have it as a judge, you're not going to be able to monitor those guardianships properly. So you have to have staff, you have to have people who care and have the heart for it, and they have to be appropriately trained. Those would be the three simple keys to it.
Thank you.
As part of our general questions, one was, what Texas state court decision do you think has most impacted society? How and why? And you referenced the Coyote Lake Ranch LLC versus Lubbock opinion, having to do with water rights and oil and gas. And needless to say, and you correctly pointed out, water rights will be the biggest area of litigation in the future, and it's actually has started already as we encounter water shortages due to population. Water is indeed an important issue. Our local officials would have us believe that we're almost out of it and are compelling us to pay through the nose for it. Can you please discuss, say in a 40,000-foot overview, the Coyote Lake Ranch LLC versus Lubbock opinion and how that's going to impact us in the future?
Well, our jurisprudence on water rights, because I think in the past, hey, water, we've had enough, it's not been a problem. So there's not been a lot of litigation over it, there's not been a lot of focus on it, and as, now we're seeing in the newspapers and everything, there's starting to be a lot of focus on it. And so what this case talked about was, so what are the rights? What are the rights when you do have water under your land and getting to it, and how much damage can be done to the top of your property to get to it? And so what the court talked about was basically equating water rights to mineral rights, like oil and gas rights. And that it might seem logical, but until someone actually says it, it's not a law. And so it leaves these things out here and it just wanders around. The reason, and that's been said one other time by the Supreme Court in Texas, but the reason the second time was kind of so important is when the Supreme Court gets cases, when appellate courts get cases, a lot of times there will be a very broad issue, like water, right? And they don't focus at the 40,000 foot range. They focus on this one specific issue that gets brought before them in that case, which just manifests in the story of that case. Oh, the cow did this, the bush got cut down, and these are the things that it boils down to a lot of times. So what will happen is you'll get a ton of slivers of the pie. So a lot of times after the first sliver, the legal community doesn't know, okay, is this going to be how they handle, is this going to be a trend? Is this going to be how this is handled in Texas? They just know that in that case, they thought it was close enough that, yeah, we're going to equate water rights to oil and gas rights. This case was important because it was the second time. And so now we're starting to see, okay, they've done it twice now. So clearly this is going to be a trend with the Supreme Court. And as a litigator and a judge, you can start saying, okay, I have two cases telling me this now. This wasn't just specifically because of the cow or the bush in the first case. This is the message they're sending me as someone who makes decisions in these cases. And so when I get a new case that doesn't have to do with the cow or a bush, it has to do with a dam, I know the message I've been sent by them is I should equate this with a mineral right, just like in an oil and gas lease. So I think that is going to push forward into tons of litigation for years to come. We're going to see that case cited.
And so with that, I'll reserve my next question for down the road.
Okay.
Judge, you had mentioned the legal community. I think you're talking about the attorneys that come into your court. What has your court done to help support them, and what impact, such as maybe the CLEs that you have in your court? Sure.
And I have to say, a lot of the ideas that I have, a lot of the things that I've done, they aren't new ideas. They're things that I've looked around the state. I've found other courts that have done things, and I've tried to bring that to Montgomery County, improve upon it, and make it work in our community. So the CLEs is actually Judge Herman in Austin he called them brown bag lunches. And I actually went to one and sat there before I got elected to see, well, how does this work? And everyone brought a brown bag in. And his account person that audits the accounts, kind of sat there and gave a brown bag CLE on, listen, lawyers, this is how we need you to do these accounts. We don't want to have to get the accounts and it's all wrong, and then it causes more court problems to have to call you back, and it costs your client more money to have to get it right. So we're just going to teach you how to do it the right way. And so I thought, well, what a great idea. And so what I do is I take $50 of my own money, the court doesn't pay for it, so the taxpayers aren't paying for it, I'm paying for it. And it costs $50 to get one of these classes certified by the state bar, so the lawyers get some continuing legal education credit out of it. So they have an incentive to come, and it's an hour, and it's free for them, and we do once a quarter. We offer some topic, and we try and outreach to them and say, hey, this is the best way to do this when you come into court. If you do it this way, it's going to go a lot better for you and your client. So we've done on a lot of things. The last one we did was on eviction, because I have a lot of probate lawyers, because probate, the estate is in court too, and so the house in the estate is in court too. So when they want to evict someone from a house that's in the estate, they come to court too. Well, guess what? Court 2 doesn't have jurisdiction, because the JP courts have exclusive jurisdiction over eviction cases. And a lot of times lawyers who only do probate don't realize that. So they waste all the time coming to my court so I can dismiss it for lack of jurisdiction and then have to go to JP2. So we just did a CLE on that to help them understand, no, go to the JP court and that judge has jurisdiction over the eviction. So we look for little things like that where we're seeing problems and then we try and hold CLE on that. The next CLE is actually going to be on an active shooter situation in the courthouse, because what we find is all the judges get trained on it, all the bailiffs get trained on it, everyone in court staff gets trained on it, but none of the attorneys get trained on it because they're not county employees. So we decided, well, let's give a CLE on court shootings, because unfortunately this is starting to be a trend. So we decided, well, maybe the lawyers would like to survive a court shooting as well, and maybe their clients, and so we'll teach them what to do. And the sheriff's department has been kind enough to volunteer to put that on.
Good idea. Have you thought about doing those on videos? I know another candidate does these videos.
She is so much more talented than me. I'm so envious. I watch those videos and I'm like, how does she know how to do this? Maybe one day she'll be kind enough to teach me and we can do those kind of videos too. But I post, if we get materials from the CLE, I post those on the website. And so if we got a video, I could post that on the website too. So it's a good idea going forward. But no, I don't know how to do those darn videos. I'm impressed though.
Yeah, okay.
Probate.
Yes, sir.
In the past, we've had problems in the county where it took years for somebody that died to try to find who owned the property or the families, and we've had empty houses sitting for years because they were tied up in probate. Is that still an issue?
I wasn't aware of that issue.
Just before you got on board.
Right, exactly. And and while I had done a little bit of probate, I certainly was more of a civil and criminal practitioner than a specified probate practitioner. So I'm not familiar with that problem from before. I'm not seeing that now. If that's happening, I'm not aware of it. But we certainly do have, people that come in, the banks a lot of times come in to foreclose. Most of the time they'll check with the family to see, hey, does anyone have any interest in this home to get caught up? And they'll say no. And then they'll come in and foreclose, or the family will get in and get the house taken care of. Sometimes what we do have with regard to houses is when a ward is put in a nursing home, their house is left vacant, and I can't let that happen because it's dilapidating the ward's property. So it's a sad situation because I have to bring the kids in. Like when they do their first accounting, I'll go, wait a second, why do I still see a house on this accounting? This individual is in a facility and I don't see that they're getting out of the facility unless I'm missing something. Then you need to tell me, what are we going to do with this house? Because you're not renting it out to make any money. It's just costing taxes and this and that and the other. And then they'll say, oh, Mom would be so sad if we sold her house. And I'm like, I know, but you're going to just have to tell her that the really mean probate judge, like, I'll take the blame. Just tell your mom I made you do it. And it's actually a law that we have to make sure and ensure those assets aren't dilapidating. So a lot of times I have to step in a guardianship and say, look, you need to go ahead and sell these assets because we know Mom's not going to come home to that house. And that's always a sad situation and that's hard for the kids. But we have to do it to make sure those houses aren't in the community dilapidating and also not damaging the estate of the person who's in care, because they might need that money later on and you want to sell the house when it's in good condition.
Okay, so we discussed that your load is half civil, and from what I understand, the 4/10 is also half civil, and the other half are both kind of family related. Why do we have two courts that are both half civil instead of just having another full-time civil court?
Well, my court is half civil, number one, because we've talked about making Court 2 a statutory county court for probate. And my predecessor, Judge Winfrey, feels the same way that I do. It would essentially make it a part-time court. So number one, I don't want to be coming in not working.
Well, why wouldn't you take the other half of the 4/10, which is family related, I think, huh?
No. So the 4/10 handles family cases and civil cases. I'm not sure there would be a point of putting family law cases into my court, because we actually have 2 specialty courts that do family, County Court 3 and the 418th, and those courts are actually equipped with associate judges that handle family law cases. And we have Judge Winfrey, who was my predecessor, actually handles CPS caseload, which is family court, and Judge, I think it's Durst, handles AG. So we actually have, in different capacities, 7 judges doing family law cases. So there would be absolutely no need for me to do family law cases or any other judge. As a matter of fact, in my opinion, we need less judges doing those kind of cases. So the civil cases, though, that are in my court, those would have to stay in my court, at least for now, because there would be no place to put them. So I'm in a position where we don't have enough probate cases to be a full-time probate court. We probably will when the county gets to probably 1 million people, is my guesstimation going forward. So we need to do something with the rest of the time, and right now, kind of the hot potato is civil cases. And I love civil cases. I'm happy to have our civil cases. We have very interesting civil cases. And there are some things that only a county court has jurisdiction over. In civil, you kind of be surprised, but condemnation cases, so these road widening cases, district courts don't have jurisdiction over them. So it has to be a county court judge, and I'm the only one who handles civil. And so like one of our last cases, so we did all the I-45 widenings, all the land that they took to expand, all the 99. So every time a road comes through, some expansion project, that case is always handled in my court. And like one of the last ones, even though county court law just has jurisdiction to 200,000, so a lot of people say, oh, they're kind of the junior judges, they're the small judges. The last condemnation case, or one of the last ones we had come through, which was on the 99 condemnation, was a $36 million verdict.
Wow.
So those kinds of civil cases are also coming through the county courts, and the district courts don't have jurisdiction to handle those cases. So we need at least one county court judge handling civil cases, and I'm that judge.
And the district court can't handle your probate stuff, huh?
No, they don't have jurisdiction, they're not allowed.
Do you handle toll roads? No, I'm just kidding. I remember Chairman.
Any road. And the funny thing is, because I'm kind of politically active in the community, I like politics. And every once in a while I'll see, for a while that high-speed rail was going to come through, and I'll catch myself starting to maybe like a page so I can follow it, and then I'll go, oh no, but wait a second, if that high-speed rail comes through, they're going to condemn the land, and those cases are going to be in my court, and I'll have to recuse myself if I've gotten involved. So every once in a while I have to remind myself, no, I cannot go to those sites. I can't be a member of that group, because if it ends up in my court. I did have one time, y'all probably saw the case with the animals, those horses that were in all that trouble in Conroe.
League Line Road.
And I had kind of been seeing it go through social media, like people were like, what's going on? Why is nothing happening? This and that and the other. And I read it and I was like, oh my goodness. And I texted Commissioner Metter and I was like, do you know about this? Look at this. What, can anything be done about this? And so he got onto it, and then he found out, that the police were going to be out there, and the DA was aware of it, and there was going to be something happen. Well, the thing I wasn't thinking about when I did that is the animal seizure that happened out of that went to JP Court, which was, I think that went to Judge, I don't know which, Judge Spikes or Judge Mack would have handled that. But then they appealed it. Well, I'm the appellate court for civil cases for the JP, and it ended up right in my court, and I went, no, the people involved in the case didn't know that I had sent that text, but I knew I had sent that text. And I said, well, I'm not an appropriate judge, because I've played a role in this, even though people don't really know it. So I had Judge Seiler, he was sitting the bench at that time, and I said, I can't touch this case, would you mind substituting in for me? And so it didn't cost the county any money for a visiting judge or anything, and Judge Seiler ended up hearing that civil case. So every once in a while I have to go, wait, this might end up in my court, I can't get involved in it. But honestly, for the animals, I would have done it again, because I can't sit there and just let that happen and not say anything. So I would have to say, please someone help these animals, and then just send the case to another court.
Yeah.
I guess I'm a little slow on learning, but in the district court, it's been determined that they need 4 full-time civil court to handle caseload.
For Montgomery County, so
For
that would
Montgomery.
include county courts and district, all of our civil caseload.
So
we
that
need
does
4.
include, so you do handle
Some of that
some of
caseload.
that,
Yes, sir.
that if we had 4 courts like they're proposing, you wouldn't have to handle some of that. Is that correct?
Oh, if we had 4 other courts, now one of them would have to be a county court, because like I was talking about, certain cases were the only ones. And right now, the way we have it delineated out for, on the county side, is we have 1 doing family, and they're full, and they're full-time, and they're working. We have 3 doing misdemeanor. The numbers look like we might be able to have 1 less doing misdemeanor, but you hate to start bottling those things around, especially because it's jail volume. So you want to kind of err to the side of caution on that. Plus, the county court judges also handle our juvenile dockets, which can be handled by district or county. So we've kind of taken on that extra load of cases. So I think that kind of fills in a little more on the misdemeanor. And then I'm the only one left, and all the probate and all that civil has to go somewhere. So I used to kind of laugh when people would say, what does your court do? And I would say, well, you know that little black fish that's on the bottom of the fish tank? We get kind of everything that's left over that no one else wants to eat. So those are the cases we handle that are just as important of all the rest of the cases, because you have litigants and you have people that need access. On the district court side, so I'm basically 0.5. I'm half of a county judge. So if I was of a civil judge, so if I was looking at that report saying that we need 4 courts doing this, 4 full-time, I would say we have 1 half with me, we have 1 half with the 410th, and we have 1 full with the 284. So essentially we have half of what we need. So when people talk about there's a backlog of civil cases, there's a reason there's a backlog of civil cases. We took 600 cases from Judge Wood last year from the 284 to help with that burden on that side. And what ended up happening was it kind of sunk our court for a while. Now, we still kept up, and we were still in a 90% disposition rate for most of the year, and then we went up over 100% disposition rate as we're weeding through those cases. But we are going to have to address the problem with all these civil cases. And it's not that Judge Wood hasn't been working. She's there, she works, I work with her. So that's not, it's just it's a high level, and right now, either the resources that we have haven't quite been appropriately distributed to handle the cases, and maybe in the future, if we add another court to Montgomery County, I believe it's going to have to be definitely a dedicated civil court, because now we've addressed, with the felony side, we've addressed getting a very appropriate number of felony courts now. They're all working efficiently. The jail number population is down now. So for a while, that was kind of the hot potato. And so all hands went on deck for that. That's now, that spigot has been quelled. We're good there. But so now kind of the next thing, which I think is the most important thing for the courts to look at, is the civil caseload and how it's allocated and what we need to do going forward.
Okay, we were talking about civil asset forfeitures before, and you mentioned that rather than law enforcement profiting, or rather than lawbreakers profiting, it seems like the law enforcement community is profiting from a lot of standpoints, to the point of, buying things maybe they don't need, taking trips to Vegas, that sort of thing. Is there a more equitable way to disperse these funds than perhaps a particular arresting officer, like I said, to pay for parties and that sort of thing? And is that something that judges can make recommendations to the legislature to change that for civil asset forfeiture?
We could, anyone can make recommendations to the legislature, but like my mom tells me when I try and get her to go to Austin, she's like, I just can't walk in their offices like you can. I'm like, well, you actually can. But I understand, you know, I have cell phone numbers in my cell phone that, you know, other people don't have in their cell phone, so I can reach out and probably get that access more quickly. There needs to be more oversight on it, because I don't agree with, you know, like the examples you're giving. You know, there are horror stories that come out of it. You hear, it's one of those things, boy, that a couple of people doing wrong things makes the whole community look bad. So I believe in my heart, and I certainly hope that that's not happening in a majority of the cases. And so what we need is, and I don't necessarily think that the money shouldn't go back to law enforcement, because in a lot of ways they are underfunded and they do need funds to help continue to fight drug trafficking and different things like that. But I do think, the thing is, right now the statute is written very broadly, and it just says basically for law enforcement purposes. You know, well, that's a big word. Now, of course, a party isn't a law enforcement purpose, really, you know. But there's a lot of things that you can fit into a law enforcement purpose, which isn't necessarily helping law enforcement go catch those drug dealers or those pedophiles or those bad people. So I do think it could be fixed. It definitely, where there is some oversight, you know, maybe, and I'm just throwing this out there because I'm thinking off the top of my head right now, but maybe these cases go through courts. Maybe when they do go through the court, maybe at that point, as part of the proceeding, the district attorney or the county attorney, whoever has brought the case in whatever county, has to designate to the judge what those specific funds are going to be used for, and the judge has to approve it. And then that way you don't have to create an oversight committee in Austin or anything like that, because you're already going through a channel where someone can give approval. That I'm saying that could be one way to handle it, but I do 100% agree. Someone needs to be saying what's okay and what's not okay, because there are monies that are being spent on things that are completely inappropriate. I agree with you 100%.
Well, and to follow real quick on that, isn't it incumbent on law enforcement to go, if they're short on something like Bulletproof Vest, to go before Commissioner's Court or whoever their governing authority is that they report to go ask for that, rather than using money from asset seizures, because then you have the potential for introducing big problems.
That's true. I mean, they definitely have the responsibility. And, you know, it creates accounting issues, because then, you know, it's like grant funding. Certain departments get so much from the county, right? And then they say, well, this is what we're running our fabulous department on. But then there's all these grants that aren't being counted in the mix. And then but they get these extra bank accounts from this and this and this and this. And so then it's very hard to understand financially. It's a more complex picture, and it's hard to audit and understand really how much money is coming in and going out. So as far as simplification purposes, that certainly would be a better way of doing it. I will tell you, from working with law enforcement and being someone who has actually gone out, and I worked a lot with Constable Hayden in East County. A lot of times when I was at the DA's office, certain agencies would call and ask for an assist and say, hey, we want you out there, so if you see something that you think needs to be seized, or you see a way to see something that we're not seeing, we want you on scene. So, and those cases always worked out well, because we were in from the beginning, and we could pre-plan, we could go out, do the execute, and then after the fact, make sure that the case got, you know, really filed properly. But what I learned from going out there and being on site and on scene is, you know, you go out into, back then, you know, I'd go out in Rowdy's office, and the guys would have their hammers and their personal stuff, and they would be, you know, doing construction in the office, you know, and they're like, well, we need this, and we just had to do ourselves, because, you know, we didn't have the money in the budget or something like that. And so in certain ways you see that there is a lack of availability of funds, and I would hate to be someone to say, well, you're already strained for funds in law enforcement, and now I'm just saying, no, you don't get those funds either. Because I see them depend on those funds, and I do see them depend on those funds for legitimate purposes and things that they do need. And so, is there definitely a better way to do this? Yes, but does law enforcement need those funds, in my opinion? I think that they do.
With the
We got
forfeiture,
about 5 minutes, sorry. Go ahead.
okay, with the forfeiture cases, is that something that's county court or district court? What's the distinction there?
So asset forfeiture cases, like the Chapter 59 cases that we're talking about, are reserved jurisdiction for district court. They are civil cases. They are not handled with the criminal case. Interestingly enough, even if the criminal defendant gets found not guilty, you can still go forward with an asset forfeiture, because it's kind of like the O.J. Simpson case where he wasn't found guilty of murder because the burden was up here, but he was found guilty of, what, I can't even think the word, basically the civil side of killing somebody. And he was found guilty because the burden was a preponderance of the evidence instead of beyond a reasonable doubt. So in the asset forfeiture case, it's a lower standard, it's a preponderance of the evidence, so you might be able to prove that where you couldn't prove the full criminal case.
And so with your court, you're running for a county court, correct?
Yes,
And
ma'am.
so your court can't handle the civil forfeiture, that's only district court.
No, ma'am,
And-
I can't. But I will tell you, there's another type, there's always an exception to the rule. So there's another type of asset forfeiture that is specifically attached to gambling cases. And so those cases are quite often brought, like those 8-liner rooms that you see that they do, you don't know about those? So those little slot machines in Las Vegas, people will get those and they'll take a building like this that they have and they'll black out all the windows and they'll basically open up a game room. I did a lot of prosecution of this when I was at the DA's office. And so they're doing their Las Vegas thing, right? And they get these they're called 8-liner machines because the lines, there are 8 lines of play on them anyway. So you can seize those monies, but those monies don't get seized through Chapter 59 because it doesn't fall under there, it falls under a different code. Those cases do go to the county court judges, but they would go to the criminal judge that the case is being handled through. So it's handled through the criminal case. So I still wouldn't see those, but I did handle them and prosecuted them when I was at the DA's office. Well, so there's a whole nother line of money that you didn't realize is out there floating around.
Well, and some of that civil asset forfeiture goes to the county as well as to the law enforcement office.
So that gets split up. Basically, the DA's office will do a memorandum of understanding with any law enforcement agency that's going to do asset forfeiture, that's going to participate in that program. So, we have a binder of them, and anybody, like SIU at the time, the sheriff's office, pretty much all the active agencies have them. And so that contract, that MOU sets up what the split is going to be. And the split actually is between the law enforcement agency and the district attorney's office. So the district attorney's office gets a share of that, as well as the agency that actually did the seizures. And sometimes you might have a task force with multiple agencies. And so if there's multiple agencies, then there's gonna be an agreement where multiple agencies might get a split of some. If it was a big drug interdiction or something and they managed to get a dealer with a lot of money, then they're kind of all gonna want
Do they do
their
that
share.
in advance? Do they
Those
say-
MOUs are set up in advance.
Huh.
Now, sometimes, there might be a seizure and the seizure happens and then before the end of the case, because the individual owns that property, of course, until a judge says they don't. So before the end of the case, because that maybe you have something that there wasn't an MOU set up on, you get it set up so everybody's on the same. And it's pretty standard. I think when I was there, they tried to go along the lines of, so if you hired an attorney to handle a case for you, and it was going to be like a personal injury, typically the attorney gets about 30%, a third of it. And if my memory serves me right, and this has been 8 or 9 years ago now, I think, it was about that same split. So if that law enforcement agency had to go hire a counsel and they took it on a basis of what you won, it would be about 30%. So the DA's office is basically a law firm, you know, and they're taking that for law enforcement. So that was the logic, I think, at that time behind the cut. Now, I don't know if that's still the percentage. That's just several years ago when I was there.
It's my understanding that the civil asset forfeiture does not require a conviction.
It doesn't.
When cops get their hands on it, poof.
It does require a final order from a judge. So it is not as easy as they get their hands on it and poof.
I said poof.
I said poof too. I have a 3-year-old, so sometimes, you know, there's a lot of the other thing, but poof, it's poof this morning, because thank goodness grandma's got the 3-year-old. But there's an actual proceeding that you go through, and they can request a jury trial. So it does have to go through trial. I will tell you, most of them don't go through jury trials. A lot of times the individual that the property gets taken from doesn't fight it. They don't go hire a lawyer. You know, you get an appointed lawyer for a criminal case. So if you're indigent, you know, you have a lawyer that's going to handle that, but you don't get an appointed lawyer for the asset forfeiture. So yeah, in certain ways, it's it might seem like poof, you know, especially if you can't afford a lawyer. And sometimes, like, so if you get your car seized and it's a $5,000 car and the civil lawyer says it's going to take $10,000 to try a jury trial, which the cheapest one I ever did was actually $20,000, and we were pretty cheap, you're going to give up the car.
Then
Because
you
at
are
that point, it just becomes, it's not worth $20,000 to fight for a $5,000 car. So you want to make sure that law enforcement and the DA's office is definitely reviewing these cases, that they're being ethical, that they're doing the right thing, because it can be an easy way to get a hold of someone's property, which then goes back to what you're saying is, if you have a law enforcement agency that maybe they do need money because they're not getting it from sources that they need it, and they see someone who's got something, and then they're like, well, that's a good target. I hope that that's not happening, but I will say that the way it's set up, there's incentive there, you know, and that's, but law enforcement in general, if you think about them in general, you know, let's be honest, there's a lot of power there. So it's not just for asset forfeiture. If someone is in law enforcement and they're mad at somebody and they want to misuse their power, well, they can. It's the power of law enforcement, and that's why you have to be so diligent with electing good, ethical officials in law enforcement, making sure you have good constables, you have ethical prosecutors, you have good sheriffs, you know, because it's from the top down. If you have the one at the top who's not going to tolerate bad actions and is going to be a good ethical person, then it's going to bleed down. And even those people will have problems in their agencies, but they'll address them when they find out about them. But, you know, unfortunately, it's just that same thing, that you have a group of people who on the whole are good people. They have terribly difficult jobs they're having to do, and it only takes a very few instances of a bad action. And it scares people, you know, because there is so much power in law enforcement. So, you know, asset forfeiture is just like anything else law enforcement does. If it's something that's going to be abused, there are other things that those law enforcement agencies are probably abusing as well. So,
Yeah. Do you have anything pressing or past our time?
Yeah,
Go ahead.
I'll go back to my question. It's been determined that four full-time courts are needed to handle caseload and civil end. And I remember in interviews in the years past, this same question has been there, and it's been said that they need four, but it keeps getting kicked down the road. My question to you is there a way, and what would you do to quit kicking the can down the road?
well, and there's a reason this can was kicked down the road. At the time the can was being kicked, we had a backload on civil and we had a backload on felony criminal. And the felony criminal backload was causing our jail to be overpopulated to the point that there were serious discussions and a committee put together and the potential of several $1 million to be used to build a jail facility. And Judge Doyle, as he should have, reached out to the judges and said, hey, we need all hands on deck with this. Either we need a new jail and we're gonna have to put out this money, or this is some other type of problem, and you're kind of a cog in this wheel, and if the backlog is because y'all aren't getting this taken care of, you need to step up and get this taken care of. So there were kind of multiple things in play at that time. Number one, the 435th, which was Judge Seiler's court at the time. That court had been created by the legislature to do these pedophile civil commitment cases, and his court was kind of like mine is in the fact that those cases weren't really taking up 100% of his time. So he was reaching out to help on the criminal side. And so he had about half and half like I do. That court now, since then, of course, the legislature has now changed what that court does and changed the way that that whole civil commitment is handled in Texas. So when that happened, that court was converted to a full-time criminal court. So then that helped ease the valve. And then, let's see what happened. Then we also took and we specialized the 359 and made that a full-time criminal court. Well, when the 359 specialized to be criminal to help take off this caseload, that court gave up its civil docket. That civil docket went to me and to Judge Wood, okay? So you see, kicking the can sometimes is about resource allocations, and at that time, the screaming fire that needed to be put out was, we're fixing to have to spend a lot of money on a new jail because of these felony cases. We need more district courts to be able to handle felony cases. Judge Hamilton's came first because the legislature was involved in the 435th. So anytime the legislature has to do something, it's going to be a longer process. So as all those cases kind of bled through, and all those processes happened, we're just getting to the point where we're at equilibrium there, basically within the past, I'd say 6 to 9 months, and things are going great. Then when the 410th changed hands, that court was the only court left. All the courts are partially specialized now. The only courts that aren't really are me and the 410th, because we're the only two that are splitting caseloads like we are. When the 410th switched judges, so Judge Mays, he wanted kind of the way that the courts were set up by the legislature with full jurisdiction. He was the only judge left that was doing a sliver of family, a sliver of criminal, a sliver of civil. And so in an effort to move that court forward to specialization, the first thing that happened when Judge Robin became the judge in that court is the criminal cases came out of that court, because at that point we did have adequate district courts to handle all those criminal cases. So now we have all the district courts, the criminal cases are where they need to be, that's totally specialized. So now you have the 410th. The 410th had a huge backlog of cases, and Judge Robin is working through those cases right now. And so right now, what has not happened is there hasn't been a come back to the table discussion about civil and what the 410th's role will be. Are they going to specialize and become a full civil court? Are they going to keep doing half and half? And this is a decision that will it lays on the Board of Judges, but for the most part, the Board of Judges in general. We've done it on limited cases, but in general, if a judge says this is what I want to do, it's not going to be the case that the Board of Judges is going to go, no, you're going to do X. When the 435th was making that decision, it was a case where we said, no, we've got this backlog in felony. It has to be a felony court. It has to. Other than that time, pretty much what the judge wants happen. It's my opinion now that the courts are kind of in their respective lanes, other than me and the 410th. Now that they've been specialized, I don't think it's a good idea, once a court is specialized, to then switch it. Like say, oh, I'm going to change this court from civil to criminal. Because what you then have is, okay, it changes this whole civil docket. Where do the criminal cases come from? Where do the civil cases go? And that cost a lot of time, a lot of efficiency is lost, a lot of money, and then you have technical problems where anytime a case is moved around, like when the cases came out of the 410th, all those criminal cases, and I talked to the Tea Party Patriots back when that court was up for re-election, and I said, look, I don't think that court should take more criminal cases. But I think it should hear the criminal cases that it has, because anytime you start moving caseloads around, cases get lost, it creates a big delay in the system, because then you're moving it to a new court, and then that judge has to re-identify and re-go through everything that's in that case, and reset out new scheduling orders, and it's just kind of it's almost like, God, this is gonna sound terrible, it would be like if you went on vacation and you went into a hotel, and then there was a problem in that hotel, and then you had to repack up all your stuff in the middle of your vacation, and you had to go to another hotel and then unpack it. And it sounds like not the same thing, but that's kind of what happens is, okay, well, we're gonna pack up this case, and the district clerk has to have their staff reassignment. So it's this big chain of work that has to be done to move these cases. So you really want to get it right on the front end. You want the case to go to the right court, and you want it to stay in that court when at all possible. So when you do start talking about case reallocation and all that stuff, I can't stand it when people are like, oh, we'll just switch that court to a this kind of court, because it's like they don't understand administratively what is happening. And that all goes downstream to the litigants who are waiting. So if it's a criminal, which a lot of times people don't feel very bad for, but when you put it like, oh, well, we are paying $50 a day for them to be incarcerated in the Montgomery County Jail, well, then it starts, making sense in a financial way.
So is there a way to quit kicking this thing down the road?
Sure, I think that we're almost there. I think we need to get definitely at least 2 specialized civil courts on the district side. And then when County Court at Law Number 2 becomes a full-time probate court, which is going to be based on population, of course, because you don't want to not use all the judicial assets. And so making it full-time probate now would leave me going, okay, well, here's a judge y'all have elected and are paying very good money to and a whole staff, but you're really not getting what you paid for. So when the population grows such that my court is going to be a full-time probate court, then you're going to need another county court on the civil side to handle those dedicated civil cases that only a county court can handle and the district court judge doesn't. So I think then you get to basically your 3, and it could be that if we have to add a new court, which you always only want to go to the commissioners when you're 100% sure these are the numbers, we're sure we need it. So the 2 problems with that is right now the 410th is still in limbo. I mean, Judge Robin has been in there a matter of months, and there is a lot of work to be done that is of no fault of her own. So she's working through what she was given. So we have to see what happens there. And then the other problem is we switched to this Odyssey. I don't know if you know, we switched to a new software, which was a good thing a few years ago. The county made this big investment. So with the old software, our numbers, the statistics, what's in the courts, what's open, what's closed, it was all messed up. It was not reliable at all. And so when the switch was going on, there was no point in fixing that, because then you're taking IT department time to fix a problem that's going to go away anyway because we're getting a new product. So we kind of went along on that train for a while. Now we have this new Odyssey program. We've just switched everything into it. So when they did the IT dump of all the cases, of course, certain cases didn't pop up back in the right place or in the right thing. So then there was this huge process that took months of making sure everything was mapped and in the right place. Now what we're finding, the most recent problem, and I'm in a court data committee, that this is what we do. We work with the clerks in all the departments, and we have the most boring meetings ever with even more people around the table than this. And we pull out reports that are generated and sent to Austin about what is in the courts. And we compare those reports to what the judge actually knows is in the court, and we're finding discrepancies. So for example, if you looked at my report that came out of the district clerk's office, and again, this is, we've narrowed it down, that it's very much related to a problem in the software. And it might be a training problem that maybe, we're not sure yet, maybe that when certain things happen in cases, it's being entered not properly, which is making the software act this way. What you will find is if you print a pending cases for my court, you might have 600 pending cases. And those pending cases all range between cases that are filed 2016, 2017, with a couple of exceptions, a handful that are just very complicated and going longer than that. That report should match with the pending cases report that gets sent and is officially recorded to Austin. But what we find is that that report might have 100 more cases or 20 more cases, and those cases might be from 2013. And so when I spot check my report to Austin, what I'll do is I go through, I'll see something that says, and you can tell by the case number what year the case was filed, I'll see something that was filed in 2012, and I'll go, not my court. I know we don't have any 2012 cases filed. And I'll pull up the case, and sure enough, the district clerk has it marked as closed in the software, but is reporting out as an open case. Well, number one, that can be used to make it look like I have not done my job when I have.
That would throw off those figures of saying that they need 4 full-time.
It could.
And
And
if
so-
you look back, that's.
So that didn't close the loop.
So when you're saying kicking the can, there are things that are taking time to work through, so that before we walk into commissioner's court and before people like me have to explain to people like you why we took, $1 million more of your taxpayers' money to build out a court, pay a new highly paid judge and all their staff, we want to make sure we're walking into commissioner's court with accurate data and that we have already used the resources that we already have to address the caseload. So a whole bunch of old cases in the 410 that was no fault of the judge that's in there right now that she's working through. And there have been a lot of conversations about when are we going to have this conversation about the 410. And we have received word back from the 410. I'm still working very hard to get through what I have. We're not ready to have that conversation yet. And then that actually goes along with the fact that this data committee is still meeting and working out the IT department thing. So we have a potential resource for those cases. We have a potential numbers problem. But do I know, based on the fact of what I actually see happening with the civil caseloads in the 284th, yes, we do have enough cases that are active and going through the courts in civil manners. We need to address, that's the hot potato right now. We need to address it. We are just not to the point, but I want you to be clear. It's not because it's not being discussed a lot, and it's not because there isn't active action being taken. It's just that what we were told was, you better get this jail problem taken care of. We addressed that, and it was a little bit to the detriment of the civil side, and so now we need to get work through. And it could be that we go to Commissioner's Court and ask for another civil court, but we can't do that until we're certain that we need it, and we won't be certain until we know the numbers for sure.
We're gonna wrap it.
I'm sorry.
We're way past.
That's just a big thing that's been going on, and there's a lot that goes into it.
Well, that's important.
And I just want y'all to be clear, because people, this stuff comes up in elections and it gets thrown around just willy-nilly, and it makes me crazy in my head as someone who's actually one of the bakers that's dealing with these ingredients. I'm like, you're taking all this flour and you're throwing it on this side of the kitchen and it's making a big mess. It's just not, you just can't change a court. There's this huge roll-off that then changes all this stuff and makes it harder for us to be able to address the issues that we already have.
So take up to 5 minutes if you like for closing.
I will, I've taken up enough of your time. We'll just call that my closing.
Thank you very much for coming in.
Thank
Thanks
y'all.
for completing our forum. We know you don't have an opponent right now, so
Yes,
we appreciate you stepping up and coming in.
sure. I always feel like as an elected official, when someone asks me a question, when someone asks me to come in and answer questions to their group, I need to do that.
Yeah.
Because that's my obligation as
A
an
lot of-
elected official.
A lot of incumbents don't believe that don't have challengers, so we
Well,
appreciate that.
we should always do that.
Well,
thank
thank
y'all,
you. Thank you
and
very
thank you for
much.
what you do.
Thank you.
Okay.